Hear ye, hear ye, hear ye. Colorado Court of Appeals is now in session. Please be seated.
All right, good afternoon. This is Division 7 of the Court of Appeals. We are set for oral argument today, and I apologize if I mispronounce Brammeier? Brammeier? Like Premier. Brammeier. Okay, thank you, Mr. Amundsen. And I see, it looks like people are ready to go. Are the folks on Olson also here?
I am, Your Honor, counsel for the respondent, Mike McAlay.
Okay, I'll wait then and address both of you once everyone gets here. All right, so in the Brammeier case, are there any questions about the policies or procedures for oral argument?
No, thank you, Your Honor.
Okay. And just to remind you, we are live streaming, so if there's sensitive information you don't want going out, just be mindful of that. And I'd ask everybody if you could turn phones off, not just on silent, because sometimes we find that we still get interference if the phones are on. Okay. Oh, and I apologize. To my right is Judge Jerry Jones, and to my left is Judge Elizabeth Harris, who serve on the division with me today. You may proceed.
Good afternoon. 75 years ago, in the Johnson case, our Supreme Court set aside a conviction that was obtained after an inappropriate reference to the wealth of the defendant. And that's the way the Charlie Brammeier case started at trial. It started with an overt reference to the apparent wealth of Charlie Brammeier's parents. During jury selection, as I often do, I ask very open-ended questions. I think it gets more information from the jury by doing that. And one of the things I typically do is I ask them to grade or rate the judicial system. And has occasionally, but not always happens, one of the themes was that people with wealth fare much better in the criminal justice system than those without. I'm mindful of that, and because, ironically enough, one of the members of the potential jury who actually wound up sitting was a defendant in a civil case, which I tried in 1976, according to him. It was actually 1979, but the jury must have known I was not a public defender. As a consequence, I revealed to the panel that I was a hired lawyer and let it go at that. And at least 3 members of the veneer, the group, wound up sitting as trial jurors. During the initial aspects of the lead detective's testimony, and this was a lead detective who was the advisory witness who was present during jury selection, in which many members of the jury expressed the same sentiments about wealth in the judicial system. For no appropriate reason, the lead detective referenced the area in which Mr. Brammeier's parents lived as a place with big houses, probably multi-million-dollar homes. A contemporaneous objection was sustained, but not to be silenced. The detective went on to say, when asked to please continue, that it had a lot of land around it, though. Now, the second objection was refused, and the court wound up taking a recess, which obviously, unfortunately, only emphasized the issue to the jury. I know that on appeal, the prosecution has urged a variety of grounds to try to justify what the detective did, but it is unjustifiable. The reference to a lot of land around it, though, was clearly, he wasn't going to be silenced. And it was an utterly inappropriate reference that took into account what multiple jurors said during jury selection.
Counsel, I want to ask you about
Please.
this. Prosecutor asked the detective the question, I guess it was kind of a question. He was asked to describe the area where the family lived. It seems to me the officer's response was directly responsive to the question. You did not object to the question. You only objected to the answer
That's
But
true.
it seems to me your real objection is to the question that you didn't object to at trial.
The area was in fact relevant. It was a rural wooded area. And the answer I anticipated would be that it was a rural, hilly area with trees, not a remark about the size of the homes and, most importantly, the cost thereof.
But wasn't it relevant concerning the delay in finding his vehicle? Where they found it? Why it was so far from the home?
Not the cost of the homes, not the cost of the homes at all. It had nothing to do with that. And it's really an indefensible remark. It is not relevant that the homes are expensive. If all the detective
Well,
had said,
counsel, that particular remark, the judge instructed the jury to disregard it. I mean, he sustained the objection, and this is such a brief remark in the context of the trial. Why should we say that that is so prejudicial? Even though the judge told the jury to disregard it, that a mistrial, an extreme remedy, was warranted and in fact required.
well, in fact, I asked for a mistrial, which was denied, so the issue is preserved for appeal.
I'm
But
not-
that wasn't the only reference. There's also the prosecutor's rebuttal closing. Instead of doing what, according to the Attorney General's office, was the theory of the prosecution, that it was the ego of Charlie Brammeier that led him to go back and inflict the fatal blows. There was a reference to social status, that he was slumming it, and the objection to that was overruled. What you really can't ignore is the number of potential jurors who talked about wealth during jury selection. It wasn't an isolated discussion, just one remark by a detective. It was a coldly calculated remark designed to pander to the prejudices of this particular jury.
That's your opinion, but the judge found otherwise. He said expressly he didn't think that that's what was going on.
Well, the judge's remarks in that respect are actually problematic as well. She literally did her best to attempt to justify the unjustifiable. She theorized that maybe there would be aerial photographs. There were none. She theorized that maybe the size of the lots might become relevant. It did not.
Well, can I interrupt
Sure.
you for a moment?
Of
then?
course.
Judge Jones talked about the size of the lots, and that was later one of the reasons why one of the deputies said that it took him 3 days to actually locate the car, even though it was 100 yards or so away from the house. So that seemed to be ultimately relevant to an issue in the case. The second point or question I have, though, is there was a photograph that was admitted, number 187, that shows the driveway and the home and generally the area. Would the jury not have, from looking at this, been able to discern that the family had wealth?
To a certain extent, but very limited. To be sure, that photograph does not reflect a multi-million-dollar home.
Well,
You-
I'm not sure,
least
I'm
in
not
my
sure I
view.
could estimate the cost of the home, but certainly it looks like a home that has a 3-car garage and is expensive. So the specific amount, I don't know, is really the issue. It's more the knowledge of there being wealth, right?
Yes and no, because this was a specific statement tailored by the advisory witness to invoke the prejudice of this particular jury panel. That the jury may have concluded that the family had some money is fine. There's nothing I can do to avoid that. But the reality is that that's not what happened. And it isn't really even the size of the lots. That implies that there's an ownership interest in an enormous amount of land. There was no evidence of that. What there was that this was a rural area, and the ownership of the place where the vehicle was found was never even established. It was never established it was on their property. And I obviously can't deviate from the record about that, but there certainly was no evidence that it in fact was on their property. The only testimony was that it was a ways away from their property, and the way it was put, it sure seemed as though it was not part of his parents' lot. But there's a difference between, it was a rural wooded area, a hilly, rural wooded area, and a place where there are big probably multi-million-dollar homes. There's really no excuse for that reference. And it wasn't just a single isolated remark. It was repeated about the lot of land around it, though, and, of course, the slumming comment.
But the lot of land around it, though, that wasn't directly connected to whether it was their land. It just talked about there being a lot of land around the house, right?
If that had been the only remark, it would not have been merely as indefensible. But it was the context that it was in. It was immediately following the remark about probably multi-million-dollar homes. And as a consequence, it really hindered the defense from the start, because now I'm looking at a jury that thinks, well, this is a rich kid, and we're not going to give him the kind of break that we should. We're not going to be fair to him. And that, of course, was emphasized by what happened with expert witness Dr. Robert Lance. I'll attempt to make a segue here unless there are further questions on issue number one.
I have one quick question on
Sure.
that concerning the prosecutor's remark in closing, rebuttal closing. Was there an objection to that?
Yes,
Okay.
and the objection was overruled, and the statement was repeated a second time.
Okay.
So,
But the context of that statement was the prosecutor's theory, which was that the defendant felt like these people that he was dealing with were simply not his level. They were people he could act this way toward because of his higher status.
this is not a question of semantics. Words have meaning, words are charged. The phrase slumming it specifically references socioeconomic status, and there's no way around it.
But even if that's so, why isn't that a legitimate theory of prosecution? That this is what, I mean, his state of mind is directly an issue here. That's what it's all about. And so if that's their theory, are you saying the prosecution can never have such a theory?
Well, not if it's based on socioeconomic considerations. He's a wealthy man, and you should view him differently than someone else. In reality, if it was just a matter of ego, I couldn't agree more. If that had been the remark of the prosecutor in the rebuttal closing, I would not have objected. But that's not what was said. And in the context of this trial, that reference to slumming it specifically related back to the question of wealth.
Thank you.
On Dr. Robert Lance, I just want to point out a couple things I may not have emphasized as well as I could have in the briefs. When the judge is, before he even takes the stand, of course, she's already curtailing what he's going to say. She's already expressing skepticism about his opinions. And there's nothing in the record to reflect why that would be. But there's certainly an inconceivable show of bias when the judge hears that he testified before the U.S. Sentencing Commission, the Federal Sentencing Commission, and she then states that it must have been on a panel about marijuana, which I'm sure she misspoke on that, and that it was there to seek lower penalties. There are only two conclusions you can reach from that, since there's no testimony about that. Either this judge had prior knowledge of Dr. Robert Lance and was utilizing it in an effort to discredit him in front of the jury, which she effectively did, or she assumed that his testimony was to assist people who were charged with crack cocaine sentences in federal court. And that's just a perfect example of how the defense was hampered in its key witness, the witness on cocaine-induced psychosis. I have a scant 2 minutes and 55 seconds, which I will maintain unless there are further questions. Thank you.
May it please the court. Elizabeth Ford Milani, registration number 48843 for the people. This court should affirm the judgment of conviction in this case. Starting with the wealth issue, the multi-million-dollar homes comment was not so prejudicial that the only way to cure or remedy this sort of prejudice was a mistrial. The trial court gave a limiting instruction to only consider the evidence and not decide based on prejudice. The comment itself did not necessarily encourage the jury to make a decision based on wealth. And furthermore, the comment was brief and fleeting. The trial court simply did not abuse its discretion in concluding that a mistrial was not warranted based on that comment. With regard to the deeming a lot of land around it comment, I think for the reasons discussed, this comment was relevant. Talk about the land around defendant's parents' home. It tied into the investigation where defendant's car was found, provided some context. And in any event, it was brief and fleeting in the context of an otherwise lengthy trial, 5 days worth. And I want to turn now to the rebuttal comments by the prosecutor, the slumming it comments. I think as you mentioned, Judge Jones, this pointed out, or this comment was a rational inference based on the evidence. Defendant talked about how he said that these people, the housemates where he had been spending time, even though he lived in a storage unit, he said that he knew they were not normal and that they were bad and because they had this certain lifestyle. So I think it was a reasonable inference for the prosecutor to say, even knowing these things, defendant engaged in this conduct with these people, so he was lowering himself. And that tied into the theory of the case, that defendant beat the victim in this case based on ego.
Counsel, I think, though, the problem with this statement is the particular terminology, the slumming it, which is rather pejorative. And is a little bit more directly related to, class, that sort of thing, as opposed to necessarily ego. And I realize the distinction may be subtle, but I think that's really what the problem here is. So how do you respond to that?
So I agree that slumming it perhaps does deal with class. I just looked this up in Webster's, and the word is, or as a verb, slum, or slumming it, to visit slums, especially out of curiosity, to go somewhere or do something that might be considered beneath one's station. So I think that's true. Perhaps this could be involved in class. And to that extent, this court has said that because rebuttal and closing arguments are rarely scripted with precision, that there is some benefit of the doubt accorded to the prosecutor. And in this case, as I mentioned in my brief, this discussion was on 1 page of transcript in the rebuttal closing argument, so relatively isolated, brief and fleeting, and the trial court had instructed the jurors previously decide based on the evidence, not passion or prejudice. So I think to the extent that this did invoke some sort of impermissible idea, it was harmless for those reasons. But I do think that this was a proper metaphorical nuance or oratorical embellishment on the evidence that was presented. Turning to this bent of mind by the trial court, or in my opinion, the lack thereof, there was no argument there was no record made, rather, at the trial that the trial court was biased, hostile, that there was this bent of mind that was preventing defendant from receiving a fair trial. So I do think that this is an unpreserved claim, subject to only plain error review. And in this regard, reversal is required when conduct so departed from the required impartiality as to deny the defendant a fair trial. That simply did not happen here. The trial court was very particular in executing her gatekeeping role for expert testimony. But in the end, she qualified Dr. Lance as an expert. A lot of the discussion about his qualifications were outside the presence of the jury, and Dr. Lance was able to give his opinion in this case. So I don't think that these comments suggested some bent of mind. With regard to, at one point, the trial court said, you can't listen in up here, or something to that effect. Dr. Lance said, I wasn't, and she said, okay. So I think that this really comported with the trial court's general obligation to control the courtroom, to control the flow of trial, and things of that nature.
Ms. Malani, can I ask you about the actual limitation on the expert's testimony? So it did seem a little inconsistent with the Watson case, and I know that you addressed Watson in the brief, but your argument in the briefing was just that, well, in that case, they hadn't asked specifically, they hadn't sort of drawn this distinction, but it seemed to me that if the defense had asked, that it would be kind of incompatible with the broader rule that was announced in Watson. So I was unclear why that rule wouldn't be applicable here.
Sure. So my reading of Watson is there's a couple of different holdings with respect to the expert in that case. One, that they were qualified to talk in that case without a medical degree. Also, that their testimony would be helpful. And then also that expert was allowed to rely on the victim's testimony in rendering the opinion. Again, like you mentioned, there was no discussion of, well, what opinion could they render? So I don't think it's inconsistent for, in this case, no abuse of discretion to say the farthest you can go in the trial court's terms is a consistency opinion. Another thing, I was rereading over the Watson opinion. The Watson psychologist, he had a basis and a background in diagnosing clients. So I think that it was reasonable for him to give an opinion that was similar to a diagnosis, I suppose. But in this case, Dr. Lance specifically said, no, I don't diagnose cocaine-induced psychosis. That's what psychiatrists do, and I'm not a psychiatrist. So I think it can be differentiated on that. And I don't think anything about the Watson opinion states that it's an abuse of the trial court's discretion to limit of experts' testimony to only a consistency opinion as the short term that we're using here.
Okay, then let me follow up on that, because in the defendant's brief, he seems to be drawing a distinction between two types of consistency testimony. Are you with me so far?
I think so, yes.
Okay, so on page 25 of the briefing, he says that the court wouldn't let the expert testify whether the defendant's conduct was consistent with cocaine-induced psychosis, but only whether the experiences described by the defendant in his testimony were consistent with cocaine-induced psychosis.
Right.
What's the difference, and why would the court have stepped in that kind of a limitation?
I think in this scenario, I think she just wanted to be perfectly clear as to the basis of Dr. Lance's testimony in that regard. Consistency based on what came in at trial, not to sort of suggest that there were perhaps other interviews or other testing that Dr. Lance had done. And I think that that was a legitimate concern, considering that when qualifying Dr. Lance, there was a lot of discussion about how he is a toxicologist and an analytical chemist. And in that regard, he does testing on substances and then analyzes those substances. So I think the trial court was just being very careful that the jury knew the basis and I suppose the box to put around this opinion. That I don't think came up so much in Watson. I think it was more, I don't think that was discussed and alluded to in any way. With regard to the heat of passion issue, again, I don't think that this court need to reach that issue. Heat of passion is a sentence mitigator for murder 2. Defendant was not sentenced on murder 2, so therefore there's nothing to mitigate. But to the extent that this court considers it, I think that the trial court properly excluded Dr. Friedman's testimony for the reasons that she went through at the 4-7 hearing, and that there was no supporting evidence on each of the 4 requirements in order to warrant such an instruction. If the court has any further questions, encourage to affirm the judgment of conviction in this case. Thank you.
Thank you, Your Honor. I was waiting for some sort of cue before I stand
Oh,
up.
all right.
The restrictions that were placed on Dr. Lance's testimony were entirely arbitrary and not justified by any case anywhere.
Counsel, how could Dr. Lance give an opinion that the defendant was in fact suffering from cocaine-induced psychosis when he had not examined the defendant or performed any testing? How could he do that?
He was actually being asked about the conduct, and it wasn't incidental, the difference between conduct and his experience described by. What the judge did was she limited his testimony to just what Charlie Brammeier said from the witness stand. And yet in Watson, an expert was permitted to testify essentially from just a transcript. Dr. Lance didn't just sit in and listen to Charlie Brammeier's testimony. His account was that he considered all of the underlying evidence. He had police reports. He had the anything but self-serving recorded interview with Detective Marquez. So he actually had a wealth of information about the case, unlike the expert in Watson. And yet, from the very start, the judge expressed cynicism and skepticism about Dr. Lance, and that continued into the trial, during his testimony. quite frankly, that really curtailed the credibility of the defense, because the defense really was based on two witnesses, the defendant himself and Dr. Robert Lance. And by completely discrediting Dr. Lance, which my belief is that's what the prosecution was permitted to do by the judge, it completely handicapped the defense.
How was that done in front of the jury? How was Dr. Lance discredited by the court?
Right, there were portions that were in front of the jury and portions outside. I only point out the pretrial to show a state of mind. In front of the jury, despite decades of testimony and being qualified as a toxicologist, that was the issue. Is he a toxicologist or is he just an analytic chemist? The judge basically ignored Rule 702 and all of the case law that says experience essentially trumps education. And when
But she qualified him as a toxicologist.
yes, but only begrudgingly so. And
Well,
I point
how
out
does
with this,
that affect?
it was
I mean, so
clearly
what?
begrudging.
It wasn't in front of the jury.
Oh, yes, it was.
She begrudgingly qualified him as an expert in front of the jury.
Absolutely. And then sua sponte said expert testimony, you don't have to believe it, et cetera. She gave a sua sponte instruction. And so it really wasn't an innocuous, off-the-record communication between counsel and the judge. It included numerous references on the record itself. I see my time has expired.
All right, thank you.
Thank you.
All right, counsel, thank you for your arguments. The case will be submitted and an opinion will issue in due course. Please come forward for the Olson case. All right, and it looks like we have both counsel who are here on Olson and are ready to proceed. All right, and I don't think both of you were here earlier, but this is Division 7 of the Court of Appeals. I'm Judge Ashby, and to my right is Judge Jerry Jones, and to my left is Judge Elizabeth Harris. And do you have any questions about the policies or procedures for oral argument? Okay, and I just remind people that we are live streaming, so if there's any information you don't want out in the public, to just be mindful of that. Okay?
Thank you.
Thank you.
Please the court. Excuse me. My name is Dale Ink. I'm the attorney for the appellant in this case, registration number 14395. I'd like to reserve 5 minutes of my time for rebuttal, if I may.
All right, if you would just keep track of that yourself.
Very good.
Okay.
I will do that. Members of the court, the case in this case is fairly simple. I was listening to the previous argument that there were several issues raised. In this case, the issue is whether or not the court correctly applied the law of common law marriage as set forth in the case of Lucero, found at 747 P. 2nd 660, to the facts as found by the trial court. We are not here seeking a reversal of any of the facts found by the trial court, but merely, moreover, a reversal of the court's decision that despite finding that both parties had admitted they were in fact married, the court found there was no marriage. It is our position that the findings by the court on I believe it was the third part of the transcript in the court's orders at page 11 and at page 16, the court made findings that on at least 2 occasions, the respondent had admitted that the parties were in fact married. Now, Lucero very specifically states, let me find it here, I'm sorry. If the agreement is denied or cannot be shown, then its existence may be inferred. Well, here, the findings by the trial court demonstrated, in fact, that the parties were married. Both parties acknowledged it.
May I ask a
Yes, ma'am.
question about that? Isn't there a difference between admitting on a couple isolated occasions, saying that this is my spouse, or introducing somebody, and there being an admission of an agreement? Doesn't the concept of there being an agreement require looking at more than just what those isolated statements might have been?
I think what Lucero says is that the agreement just needs to be mutual, and if it is acknowledged by each party, I believe it is a mutual agreement, as set forth in the Lucero case. Certainly, there are, I suppose, degrees of what would we call them, reliability, or degrees of importance. I would submit that statements made to healthcare providers and law enforcement officials might be a little higher on that scale than just casual introductions at the neighborhood barbecue, for example. In this case, Ms. Boyd admitted that that Mr. Olson was in fact her husband. She told the doctors this. She told the sheriff's office that. Now, these are not casual admissions like they would be at the neighborhood barbecue, but these are very serious situations that certainly would indicate both the truthfulness of the statement and the fact that Ms. Olson or Ms. Boyd herself believed it.
Counsel, that sounds like an argument for the trial court. I mean, that sounds like a credibility argument. We don't get to make those. It seems to me you're saying that because of those 2 statements, the trial court could not consider any other evidence concerning their 20-year relationship and whether they had an agreement to be married. Is that your position?
Yes, sir.
Okay.
Yes,
Well,
sir.
let's assume you're wrong about that. If you're wrong about that,
Okay.
can the trial court's ultimate finding that there was no common law marriage stand based upon the evidence it did consider?
It almost sounds like, Judge, that you're asking me whether or not I think you can overrule the trial court's findings of fact.
No, I'm not. I'm
Okay.
asking. I'm looking at all the findings of fact.
Okay.
You're not. You're saying we shouldn't. You're
No,
saying
no.
the trial court shouldn't have. You're saying the trial court should have stopped when it found those 2 so-called admissions, and you'd say not considered anything else.
Yes, sir.
But the trial court did and made factual findings based upon those other circumstances. So I'm looking at all of them.
Okay.
But you're saying I shouldn't.
That's what I believe Lucero says, Judge. I believe in the Lucero decision, it says that if the agreement is denied or cannot be shown, its existence may be inferred, which would be the inquiry of general repute and the other lifestyle and other circumstances that the parties engage in over the period of time.
But it was denied. She denied that she was common law married.
She did, but the court found that she had admitted she was married on
Not
these
to
2
the court,
separate
though.
occasions.
She had not admitted it to the court. She had.
True.
She had made representations over a 20-year period to 2 people.
Well, those were the only 2 we could find, Judge. If you remember in the transcript, there were a couple of other witnesses who said she made statements along the way that they were in fact married. But I believe what Lucero says is that the court's first inquiry is, was there an agreement? And it's our position that the admissions from Ms. Boyd demonstrate, and Mr. Olson, demonstrate that there was in fact an agreement to be married. Otherwise, for example, you've got people who've been together for 15 or 20 years. When they started out, they had an agreement to be married. Over the course of the last 5 or 6 years they're together, one of them may change their mind and start to say, no, 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 we never were. Well, then we've created a situation where we had a common law marriage to begin with, and now we're going to have common law divorce. And so if the court is to find the agreement, if the court is to properly inquire under Lucero, the inquiry should be that whether or not the agreement to be married can be established. What we think it shows here is that both parties to the agreement acknowledged the existence of the agreement. And that would be, if I may, Judge, I don't think you can get a little bit married or a little bit pregnant. I think either you are or you aren't. I mean, you don't get to say in 2014 at the hospital, yes, we're married, and then pop up later and say, no, 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 we're not. I think that.
Why not? I mean, why not?
Well,
Which controls? Why do we have to say that the so-called admission controls and the denial is irrelevant?
well, I don't think Lucero intended for people to be able to change their minds and create common law divorces.
Isn't
Well,
that what the, sorry.
That begs the question whether they're married in the first place. It's only a common law divorce if they're married in the first place.
True.
And that's a factual determination by
Well,
the court.
It is, and we believe that the facts as found by the court, I mean, what the court did was said, on at least these 2 occasions, she said she was married. There were many more occasions that she said she was not. Well, you can't have it both ways.
Wasn't that the role of the court, though, to try and come to a conclusion as to how to reconcile those different and inconsistent circumstances? And then decide whether, on the basis of those statements and the other evidence, there was an agreement? Because it seems we're not just talking about an admission on a couple isolated occasions. We're talking about an agreement to be married.
Well,
So,
the court was to make the findings in accordance with the evidence that it was presented with. And it's our position that a proper application of the law under the Lucero decision would have led the court to say, all right, the agreement has been established by these statements from Ms. Boyd and Mr. Olson. So therefore, we have the agreement to be married. Both parties have acknowledged it. Essentially, if a person is in a relationship that may or may not be viewed as a common law marriage, that person needs to consistently maintain that position. If you make that representation, I don't think there's a requirement that you get up every day and say, hey, we're married today. I think that if there is the agreement as demonstrated by the admissions of the parties, I think that then I'm not arguing with the court's findings. I'm arguing with the way the court applied Lucero to those findings, because I believe Lucero says that you look behind or you look into the circumstances of the parties if you cannot, if the agreement cannot be shown. Here, the agreement was shown by the statements of both parties. And these were statements made in very serious situations, medical care and seeking law enforcement involvement in a case.
Mr. Wright, can I interrupt and just ask a couple questions about the record?
I'm sorry?
Could I ask you a couple questions about the record? You said that in addition to telling the hospital staff that she was his spouse, that Ms. Boyd also made a statement to the police. It seemed to me that the court did not definitively determine that in fact she had made a statement to the police that Mr. Olson was her husband. That's my first question, sorry. And then, keeping that in mind, you also mentioned just a few moments ago that there were other people who testified that Ms. Boyd had told them that the 2 of them were married. Who are those people?
I believe the Mr. Olson's daughter, and I believe that his name escapes me. I'm sorry. There was the witness who said they were snowmobiling past the house.
Right, okay. But the court said, I don't believe him. Okay. Okay, so can you clarify what the court did find with respect to the statement to the police officer?
Certainly. I believe that if you look at the transcript, the third part of the transcript, the ruling of the court, at page 16, lines 17 through 19, you will find that the trial court did in fact find that she made those statements to Deputy Loya.
Okay.
I see I have 3 minutes and 50 seconds left. If there are no further questions, I'd like to reserve what's left for rebuttal. Thank you.
Thank you.
Thank you. Excuse me, may it please the court. My name is Monica S. McAlay, attorney registration number 28392, and I represent the respondent and the appellee, Ms. Dorothy Linda Mae Boyd, who is present with us today with her son. We are asking that you affirm the ruling of the Lake County District Court, and that there was no common law marriage, and also that you award Ms. Boyd her attorney fees and costs in this case. This is a case of well-settled law, and it's the cases that came before Lucero. Lucero is sort of the foundation case, and then there's the progeny that has followed Lucero, which has further, like Crandall, reaffirmed the test. And there are two parts to the test. And what the petitioner keeps forgetting is that second part of the test. He first of all, so just to state, and I know this court knows it better than I do, but it is a mutual consent or agreement of the parties to be husband and wife. So the agreement part, followed by a mutual and open assumption of a marital relationship. And that is comprised of two parts: cohabitation plus holding yourself out as being married. And so what we have here is a situation where, and I believe Judge Jones referenced it, what the court said in its oral finding was it found that on two occasions Ms. Boyd referred to being married, and that was the law enforcement and the Swedish hospital, referred to. And that's what he said. There was no legal admission. I mean, Ms. Boyd has contested that they were ever married from the get-go. As far as other witnesses, that is the job of the trial court. And you saw, we had, 2 days of witnesses, almost an entire 2 days of witnesses. And Judge Harris, you asked about, some of the other people coming in. There were plenty of people who came in and said, oh, I called her Miss Olson once, and she corrected me and said, no, my name is Boyd. Or at a wedding, a relative said, oh, is that your husband? No, we're not married. It is the job of the trial court to make this credibility determination and to review the evidence, and it's a factual determination. And the petitioner keeps trying to really ask you to reverse this as a matter of law, but that's what Lucero says isn't proper, and that's what isn't allowed. But even if this court should find there was an agreement based upon those two statements, even if you found that agreement, that is not enough. That is not enough for a common law marriage, because the trial court listened to all the facts, reviewed all the evidence, and the trial court found, number one, there was no express agreement to be married, and number two, there was no implied agreement. So the court had to look at the conduct of the parties. So on the one hand, petitioner is saying, oh, when the court made that finding, again, they were not legal admissions, that the court was supposed to stop. He's completely ignoring that the court found there was no express agreement, number one. So therefore, the court was required by law to look to whether there was an implied agreement. And with the implied agreement, we have to look at the conduct of the parties. And that's what the court did, and this court did an excellent job. And if you read that opinion, they went through, and it's plainly correct. Well, the person on the snowmobile, as Judge Harris referenced, well, we know it was 2 a.m, he'd been drinking, and snowmobiles are allowed. So I'm not gonna give that a lot of credibility. The judge also referenced, well, you know, the brother, for example, you know, well, we know they had a business dispute. So he weighed all of that. That was his job. And so we believe that this is absolutely clear, and the evidence has to be clear, convincing, and consistent for a common law marriage. And the judge referenced that in his holding, that by a preponderance of the evidence, he could not find an agreement to be married. I mean, remember, one of the things they looked at was petitioner couldn't even say when there was an agreement to be married. And I'm not going to go through all the factual findings, but there, you know, all of the things of they didn't have bank accounts, they didn't own real estate together, they, Ms. Boyd always filed her taxes separately as an unmarried woman. All of these things, along with the failure to hold themselves out as married. All of that is why we believe that this is frivolous as filed. It's plainly correct. His arguments are contrary to the law. It's also frivolous as argued. He has failed in the reply brief to set forth the second part of the Crandall test. He states that the second part of the Lucero test, which is also the Crandall test, of course, is cohabitation only. It's not. Lucero is so clear on that point. It is cohabitation plus holding yourself out as married. And he hasn't established that. Again, he states that there was an express agreement. The court didn't rule that way. He also says that these two admissions, he calls them admissions, of course, equal a marriage. Again, forgetting the whole second part of the test. We believe for all of these that it's frivolous as filed, frivolous as argued, and we ask that the court affirm the decision and grant Ms. Boyd her attorney's fees and cost, and as of through the end of today, her attorney fees are $15,240. If the court has any questions, I have time and I'm happy to answer any questions, but we believe this is pretty clear. Thank you.
Please the court. In this case, the finding by the trial court that the parties were in fact cohabitating, that both parties admitted they were married, mandated a decision under Lucero that the parties had the agreement to be married and therefore they were married.
Mr. Ink, do you agree that it's a two-part test, that there has to be an agreement and then there has to be another part that's satisfied by the evidence, which is the cohabitation and holding yourself out as married?
Yes, and here, did they hold themselves out? She represented both to law enforcement and to the medical providers that they were married. That's being held out as being married.
Okay, but at least as to that prong, can't the court weigh the evidence to determine whether or not they held themselves out as married? You say the court can't do any weighing on the first prong.
Right.
As soon as there's some reference to them being married, that's it, no more weighing. But as to the second prong, why
Right.
can't the court
Otherwise-
weigh to determine?
Correct. And that would have to be the case because otherwise, there are any number of short-term rendezvous at various hotels that, when checking in as Mr. and Mrs. Smith, it might render itself to claims of common law marriage without the second part of that test, without the cohabitation.
Okay,
So,
so if you
yes.
agree that the court can consider all of the evidence in the record, at least with respect to the second part.
Correct.
And if you agree that you're not challenging the court's findings, then isn't that sufficient, even if we
Well,
were with you on the agreement part?
I guess, Judge, what I'm arguing is that the cohabitation itself was acknowledged as part of the bifurcation agreement. We knew they were cohabitating, they were living together. Whether or not they held themselves out, certainly that was something that the judge should have done. But what he missed was that there was an agreement to be married. That was where he missed the case. And what we're asking the court to do is to reverse the trial court's application of the Lucero decision to the facts as found by the trial court, reinstate the case at the trial court level, and remand for further proceedings. Thank you.
Thank you. All right, thank you both for your arguments. We will take the case under consideration and issue an opinion in due course.
Thank you.
We'll be in recess.